All rise. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Honorable Justices of the Supreme Court, all rise.
Second case on the docket is appeal number 125.
All persons having
in the
business
matter of
before this
Terrence J.
court
Malone,
are admonished
original
to draw
action
nigh.
attorney discipline, no briefs filed.
Honorable Justices of the Supreme Court, all
The
rise.
second case
Hear
on the
ye,
docket is
hear
appeal
ye,
number
hear ye.
125.
All persons having
in the
business
matter of
before this
Terrence J.
court
Malone,
are admonished
original
to draw
action
nigh.
attorney discipline, no briefs filed.
Honorable Justices of the Supreme Court, all
The
rise.
second
Hear
case on the
ye,
docket is
hear
appeal
ye,
number
hear ye.
125.
All persons having
in the
business
matter of
before this
Terrence J.
court
Malone,
are
original
admonished to
action
draw nigh.
attorney discipline, no briefs filed.
Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, all rise. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh. Honorable Justices of the Supreme Court, All rise. All persons having business before the department are watched or not. The Honorable Justice is in court. All rise. All persons having business before the department are watched or not. The Honorable Justice is in court. All rise. All persons having business before the department are watched or not.
I would encourage you
The Honorable Justice is in court.
court to
All
read
rise.
a very unusual record.
All persons having business before the department are watched or not.
Very unusual. I would encourage you, but getting to the point, Barbara Sullivan's trial was that her son actually shot Gary. That was the crux of the defense. That was the whole defense. No other. But getting to the point, the Barbara Sullivan trial was that her son actually shot. But that was stated, that was during the crux of the trial. The district court limited the cross-examination of Pat. But it was a arbitrary thing because he was the target of actual defense. But that was stated like that was during the crux of the trial. Two key areas. The district court limited the cross-examination of Pat. Hospitalized arbitrarily after because he was the target of defense. But that was stated like that was during the crux of the trial. Two key areas. The district court limited the cross-examination of Pat. Now, as far as the hospitalization, the district court disallowed proper character during the defense actually rose now, as far as the trying to bring those district court statements showing that
I didn't notice any kind of profit when the evidence was disallowed. First of all, is that correct? And if it is correct, how does that affect appellate review?
Well, like I said, we're kind of given the record that we have, unfortunately, and I believe there was a proffer of what that was going to mean, and they mentioned, and I believe that's in the 157 to 162 of the volume 16. But that was the part about him being hospitalized, I believe. And they did proffer that they believed it would show that he was depressed because of his own actions, and he was depressed because of the way he felt about his mother being in jail and actually killing his father. I believe that was in there. I don't think it was a very well done proffer, but I think they made the point, they made those arguments.
Is there anything else other than that? And I agree there.
I don't believe so. I don't believe so. Now, on to the second issue.
Before you move on, I'm
thank
sorry.
you, Ron.
Wow, sorry,
Sure.
my mic is really hot, apparently. Explain to me why that evidence, if the testimony would have been as you have described it, why is that admissible? Why is depression relevant to his state of mind or irrelevant to the identity of the shooter?
What they argued was that went to the impeachment of his testimony, impeachment of his statements that there was nobody else that had any reason to kill his father. And I believe that's how that was argued in the district court. But really the answer is.
So it wasn't offered then to show his state of mind in terms of, he was depressed because he actually shot his father. You're saying it impeached his testimony that nobody else would have been a suspect beyond his mother?
Well, it was kind of a mixed argument in the district court, and I can't just come up with anything new on my own here because we have the record that we have. And that's why I encourage you all to read the record because it's very unusual. But the argument was that for several reasons, but mainly that it showed that he was depressed because he had done it, number one, and that his mother was taking the rap for it. Now, yeah, I think that pretty much covers what the argument was in the district court and what we have. Now, as far as the other suggestion that he had made a statement to his girlfriend through some kind of social media, and this is a little bit murky in the record, that he made a statement that he could kill and get away with it because he'd already done so. Now, that in the trial, in the transcripts we have here is not as clear as what they made it out to be at trial. She admitted that maybe he had threatened her when he was in his depressed state and on medication. But the question there is that was a direct contradiction of what he had said. I've never threatened anyone ever.
But is that part of the record? Because that was from a motion hearing,
That,
wasn't it?
that was part of a motion.
So
hearing,
can we
yes.
consider that?
I think you can consider the entire record, yes. But I don't know that it's not part of the trial record at all because they didn't, and I don't know why they did not call the young lady to the stand after the court suggested they should. So I'm.
So your position is that even though it's not in the trial, we can consider that as a proffer?
Well, they made it as a proffer, but there was no evidence to support their proffer within the trial transcript. That's how it was presented at the district court.
In the motion hearing?
In the motion hearing. Well, no,
Trial.
in the trial. In the motion hearing, they asked her a lot of questions about all of these, the hospitalization, about the threats he'd made to her and the threats that apparently were on social media but those did not pan out in the motion hearing at all either.
Okay, but what I'm trying to get to is, did they make that connection in the trial?
No.
When the motion was, when the objection was made by the state and sustained?
I'm sorry, no, they did not. That's another trial for another day.
And so was the purpose of this veracity and dishonesty? Was that the purpose of it, trying to admit this?
That was to admit it for his credibility versus veracity and dishonesty, because they were saying that it directly contradicted his previous statement that he did not threaten his father ever, and he never threatened anybody else.
So this would be a specific instance of conduct?
Well, that's what the judge thought it was going to be. That's what the district court thought it was. But if it was a specific instance of conduct, or was it a inconsistent prior statement that directly contradicted what he was saying on the stand, that would be fair game for impeachment of what he was saying. That's not actually true because you said this before, and that was their argument, and I think that was a valid argument. It's just that the district court took it as actually in that particular instance, he took it as irrelevant, if I believe so. Yes, one was irrelevant and one was a character evidence. So yes, that was determined to be irrelevant to the case.
Counsel, and on that point, in terms of the impact on that limitation in presenting the defense, the district court made clear that the defense could have called her to the stand and had every opportunity to do so to impeach that testimony. Is that a fair characterization of?
I believe that's entirely fair. I can't get in the minds of district court counsel, and I'm not going to try to at this point.
Okay.
I'm not trying to be rude or anything like that. I don't know why they wouldn't have done that, and I don't know why they didn't do it.
And how do we then, what impact does that have on your confrontation clause challenge if they had the opportunity to confront him?
Well, I would reply.
Patrick, that is the him, sorry.
Yes. Well, I would reply to that hearsay evidence, it's an hearsay exception which would be a statement against interest or admission against interest. And therefore, we didn't necessarily have to have her testify if it's an admission against interest. So that would be why it could come in. Okay.
I understand your argument. Thank you.
Okay. Now, the second issue, and I'm just going to move on because the second issue is whether there was sufficient evidence to convict. And as I said before, or as I will say, this court can't reweigh the facts, but it can determine if there's sufficient facts to support the verdict. And in this case, if there was no statement, as I said before, if Gary had not made a dying declaration or said what he said, we wouldn't be here. Probably not. Certainly Barbie wouldn't be the one that was brought before the court the next day and then, or addressed the next day and convicted. They would have actually had to do some more investigation and done an investigation beyond what she was doing the last several days. Now, with that said, there was significant evidence about Gary's state of mind when he was making this dying declaration, whether he was able to make intelligent answers to the questions that he was asked. I would submit if you take away the questions being asked of him and just what he was saying, he could have just been asking for his wife to say, hey, this is my wife, get a hold of her. I need her here, or I need her to be at the hospital. If you took away the questions, his statements would have been pretty consistent with the person that was dying or that was had been shot and wanted his wife there to support him. So with that being said, I don't know. The only other evidence putting her at the scene was a very dubious eyewitness account from a person that took 3.5 years to make that identification on her profile.
Well, what about the shell casings that were found in her apartment that matches the weapon that was used to kill the victim?
Those are a problem for the defense. They certainly were, and that's why they suggested that Patrick was the one that did it, because he had access to, or had access to the weapon before and could have framed his mother. But as far as putting her, that doesn't put her at the scene. It does put her gun at the scene, certainly.
My understanding, the jury saw the video.
Oh, yes. Oh, yes. Multiple times. And that's one video I never want to watch again.
Pradesh?
Thank you.
May it please the court, excuse me, Chris Elslager appearing on behalf of the state. Once again, I'm pitching in relief today, this time for Leavenworth County. But I have fully reviewed the record, and honestly, I don't think there's a whole lot here to this case. The two evidentiary matters are reviewed for an abuse of discretion. You'd have to take the position that no reasonable judge would agree with the trial judge here. Honestly, looking at both of those, I was scratching my head wondering, well, what's the relevance of this? As far as Patrick going to the hospital and seeking treatment for depression after his father was murdered, I'm not sure how that tends to prove any material fact in the case, other than like any person whose father was murdered, he understandably unhappy and depressed. And I don't think that would in any way, by any stretch, be an indication of guilt. I'm not sure. I really was at a loss as to what that particular evidence was supposed to be relevant to. And it certainly wasn't character evidence. I mean, the district judge got that right, and it just wasn't relevant. And as far as the purported,
Counsel,
yes.
what's your position as to whether or not the evidence from the previous motion hearing, but not the trial, could be considered by us as a form of proffer?
Well, I mean, it is part of the record. I mean, it was presented to the district judge. As I said at the outset, I'm pitching in relief. I've read the record, but I'm not 100% as well versed in the pretrial proceedings I would have been had I, written the brief and so on. And so I don't recall exactly what was in the motion hearing, but just as a practical matter or as a matter of procedure, I would think it's part of the record. If, the judge heard it and relied on that in making his ruling, of course, I think the court should.
We can consider.
I would think so, yes. I mean, if the district judge relied on it in making his decision, then yes. I mean, we're here to review the district court's decision. That said, I mean, I just don't see the relevance of either one of these particular issues. The purported threat was, from what I read in the record, was not exactly how it was presented in the.
Does it matter that there was a different judge who heard the motion?
It depends on if the judge that made the ultimate ruling considered that motion evidence in making his ruling.
How are we to know that?
I have to look to the record. And if it's not in the record,
We would have to say it.
well, I mean, that would be helpful, I guess. I guess you just have to look at the record and infer. I would say in this case, though, that regardless, I mean, I just don't think there's any, if you consider all of that, even, there's just nothing here. There's no reason for this evidence to have been admitted. It just wasn't relevant. It didn't really, it wasn't relevant to the material facts that the defense was trying to make it to be. I mean, it was just too much of a stretch. The threat was purportedly, he said something along the lines to his girlfriend, well, I could kill you, get away with it, or something like that. But it wasn't, he didn't say that he'd killed before. He didn't make any threat to his father, which was what the issue was. So it wasn't relevant to that material fact.
But counsel, he had just testified that I've not threatened anyone. So wasn't the purpose to impeach that testimony?
I mean, arguably so, but the defense didn't really, my take on the record, they just didn't really they didn't connect the dots. And it came across as if they were trying to say, well, it showed that he had threatened his, that he had threatened his father, that showed it, but he didn't. And my recollection is that they also kind of mischaracterized what he said when you look at what she testified to. But ultimately, it really is, it's a matter of discretion for the trial judge. The trial judge thought it was just too attenuated to meet what the defense was trying to link it to. And so I don't think the judge abused his discretion in keeping it out. And ultimately, even if you were to decide that, well, the judge made a mistake, given the evidence in this case, it wouldn't have made a difference. I mean, what this case came down to was, as my opposing counsel said, the dying declaration, as he was lying there bleeding in the parking lot, and the people from the apartment complex clustered around him and asked him, who shot you? He said several times, my wife. When the police arrived, they asked, who shot you? He said, my wife. And they said, who is she? He said, Barbara Frantz. And multiple people heard that. So you had, I think, 5 eyewitnesses plus the police testifying that he indicated she shot him, and it was on the body cam. And when you get to the sufficiency evidence argument, really all the defense is arguing is that this court should reweigh the evidence and reassess the credibility, that you should discount the eyewitness testimony. There's some argument that it's amenable to different interpretations, except nobody at the scene interpreted it any other way. Everyone heard him say, my wife. He had the expert, Dr. Johnson, testify that, well, with his injuries, he may not have had enough oxygen to his brain to be completely coherent. That's a possibility. That's speculative testimony. And the other doctor, Dr. Handler, who performed the autopsy, he said, no, I mean, he would have had trouble breathing, but there's no evidence that he would have been, his coherency or thought processes would have been interrupted. And the jury is free to give what weight and credit to each of these experts they wanted to, as well as the eyewitnesses. And that's their prerogative as the finder of fact. And it's not this court's role to reweigh the evidence and reassess the witness credibility. So under the standard of review, the court must conclude that there was sufficient evidence to support the convictions.
Can I ask you one question on the motion for judgment of acquittal at the close of the state's evidence? I think it's issue 2 in the briefing. my understanding of the record is they move for judgment of acquittal at the close of the state's evidence. That's denied. The defense then presents their own evidence challenging the elements of the offense and does not renew that motion at the close of all of the evidence. And does that constitute a waiver then on appeal under our case law?
Well, I think in the context of sufficiency of the evidence claims,
Oh, no, I'm talking about their challenge to the denial of the motion for judgment of acquittal at the close of the state's evidence. There is a separate issue
Right.
on sufficiency.
well, I believe procedurally, yes. As a practical matter, though, the same arguments were rolled into the sufficiency of the evidence argument. So I think in this particular case, it doesn't matter.
Right, but the proper vehicle then to get to the substance is through the sufficiency challenge as opposed to the motion
Yes, I would agree
or
with
the
that.
denial of the motion at the close of the state's case.
I would agree with that, yes.
Okay.
There are no further questions. That concludes my argument, and the state would simply ask that the court affirm the convictions. Thank you.
Mr. Dash, you reserve 3 minutes.
I just want to touch on two issues. First off, I think the legal standard review could also be de novo because it was a legal decision made by the district court under, it was analyzed, the first issue about the limitation of cross-examination, he analyzed it under character 6448 analysis rather than whether it was a statement against interest or a hearsay exception under 6460. So I think he made an error of law in doing that under the wrong statute. Besides the general overview of the Sixth Amendment right to confront. Now, as far as Justice Wall's question, I think they did renew their objection to the motion for their motion for judgment of acquittal in the motion for new trial, which was lengthy, and it came a year after trial, which was, another unusual thing. But I believe they did renew that and preserve that for appeal.
After the verdict.
Yes, I believe so. That's all I have.
Thank you, Mr. Dash.
Thank you.
Thank you to both counsel for your arguments this morning. The court will take this case under advisement. Thank you. Now transition to the next case of 125292 in the matter of Terrence J. Malone. Before I ask counsel to again state their appearances, I would announce that both Justices Biles and Justice Standridge have recused themselves from the hearing of this case. That means they're not only not physically present in the courtroom, but that they are not participating in the decision of the court in this matter, will not participate in our conferencing or review of draft opinion or in any other way be involved in our decision-making. That, counsel, would you please state your appearances?
May it please the court, Tom Stratton, appearing for the Office of Disciplinary Administrator, and request 3 minutes rebuttal.
Respondent appears in person by John Ambrosio. We're ready to proceed. He would like to address the court after the conclusion of my argument, if that's the court's pleasure.
Fine, thank you, Mr. Ambrosio. Bratton?
May it please the court, this is an uncontested disciplinary action. The only issue before the court is appropriate discipline. It is helpful, I think, to have a strong grounding in the facts in this case, as the facts are very suggestive of the discipline that we have proposed a 90-day suspension for Mr. Malone with no reinstatement hearing. Mr. Malone is 73 years old, was admitted to the bar in 1975. He's engaged in private practice in Dodge City. He's well respected, as shown by the testimony of 4 character witnesses on his behalf at the panel hearing. And excuse me, also when one considers the many letters that were written in support of him. But in this case, things went seriously awry. In mid-July of 2019, Mr. Malone agreed to represent SR in a criminal case in which there were 3 charges, the most serious being aggravated assault of severity level 7, personal felony. There was an oral agreement for Mr. Malone to be paid a $5,000 flat fee. Mr. Malone had previously represented SR, and it was understood that SR would make payments. The initial payment in August 2019 was $1,000. On August 8 of 2019, also in accordance with their agreement, SR provided his title to a Yamaha motorcycle to Mr. Malone as collateral for the remaining $4,000 that was owed. SR represented the motorcycle was worth $6,000. In August and September 2019, SR made 3 $100 payments. In late November, Mr. Malone negotiated a plea on SR's behalf to a single count of criminal threat, a level 9 felony, for which there was presumptive probation. In early December 2019, when SR attempted to pay $800, Mr. Malone refused it. By December 17 of 2019, Mr. Malone titled and insured the motorcycle in his name, valuing it at $2,000. On January 8 of 2020, Mr. Malone texted SR to say he didn't want to sue him and offered to sell the cycle back to him for $6,000. The offer was made despite the fee being $5,000 and the $1,300 payments that had been made. At that time, he mistakenly believed his fee in the case was $6,000, not $5,000. And on January 27 of 2020, Mr. Malone reported to the Dodge City Police that SR had stolen the motorcycle, and 2 days later, he filed civil suit against SR for the return of the cycle, for which he asserted a $6,000 value and for damages at $50 per day, beginning on December 10 of 2019. More litigation followed. When the smoke cleared, the parties settled on the following basis. SR's legal fees owed to his attorney, Mike Giardine, in connection with the civil litigation was acknowledged to be $5,386.50. The remaining fees owed by SR to Mr. Malone in the amount of $3,700 were deducted, resulting in a responsibility for payment by Mr. Malone to Mr. Giardine of $1,686.50. In addition to paying that amount, Mr. Malone paid SR $500 to cover the cost of the retitling of the motorcycle in SR's name. The panel found violations of KRPC 1.A, conflict of interest, current client-specific rules, 1.9C, duties to former clients, 1.15A and C, safekeeping property, and 3.3A, candor toward the tribunal. The 1.8 conflict occurred when Mr. Malone acquired an interest in the motorcycle adverse to SR, and there's a number of ways in which 1.8 was not followed. There was no written agreement stating when the full balance would be due or when Mr. Malone could take or obtain title to the motorcycle, or regarding the value of the motorcycle. Mr. Malone's request for $6,000 created uncertainty regarding how much SR believed was owed to him. Mr. Malone didn't advise in writing the desirability of seeking advice of independent legal counsel before entering into the agreement to accept the title to the motorcycle, and a written informed consent was not obtained from SR.
Counsel, I just have a couple big picture questions about this arrangement. I'm not sure that it will change the outcome of this case, but this whole taking something as collateral in the context of an attorney fee agreement is interesting to me. I'm not sure our rules really address that, and I wanted to get your kind of big picture take on this. Is an odd fee agreement structure that, and I guess one way to just ask the question is, had the client simply turned the motorcycle title over as payment, we wouldn't have these kinds of issues, would we? That the problem is that effectively, counsel was loaning his client the money to pay the bill and taking something back as collateral. Is that the basic problem?
I don't know if it was ever discussed as a loan, but.
Well, when we talk about collateral, we have to be talking about a loan, right? That's what collateral is.
It was discussed as collateral. I do believe the rules address this situation squarely, though, at 1.8. And in addition to 1.8, some of the comments there too. It's not unheard of that property is provided to an attorney. And that's the reason for the existence of that rule, I believe.
Well, wouldn't that be property to hold in trust? Which is still, it still is property of the client, which is held in trust to draw against.
Part of the problem here is there was no written agreement, and it's very difficult
Right.
to determine exactly. And the hearing panel found there was no particular meeting of the minds and laid, I think, the blame on Mr. Malone for that, for not having a written agreement.
And I understand that's an additional problem here. I'm interested in your position on whether or not, let's say there was a meeting in the minds and this was all documented fully and appropriately. Would that be appropriate? Is it appropriate for a lawyer to loan his client money and take it's not a mortgage, but take collateral on a vehicle title?
That would be speculation on my part. I really.
You don't, and I realize I'm asking a question sort of outside the scope of this particular case, but I'm curious whether our rules are sufficient to kind of cover these unique and creative financial arrangements.
If this were a trust arrangement, I would assume that one would need to look beyond 1.A. And respectfully, I believe this was a payment arrangement. The term collateral was used, but I believe it was in payment, and the expectation of SR, as he explained at the hearing, was that the title would be held until the fee was paid in full, then the title would be returned.
I have a kind of a big picture question, basically related to the plea negotiation that was worked out, and it pled to a crime, level 9 felony that resulted in probation. There were conditions of probation that I assume were negotiated to. And Mr. Malone then reported a theft based upon the collateral that he had accepted, basically violating, just by reporting that, violated the terms of his client's probation. Was there any ramifications as a result of the report of the theft? Because that violates the terms of the probation that he negotiated. And I'm wondering, was there any exploration by the panel or by you as to that kind of?
Yes.
I don't know if it's a breach of the attorney-client relationship, but it seems to impact, at least my concern is, as to what kind of duty the attorney has to his client.
Yes.
And reporting a violation of the probation that he negotiated.
Yes. The next violation, 1.9C, is in part due to Mr. Malone reporting the theft of the motorcycle. He knew that the report could disadvantage SR, including but not limited to potential revocation of SR's probation and SR's incarceration.
Well, he reported a violation of the probation. I mean, just by reporting a crime that his client committed violates the terms of the probation that he negotiated.
Yes, and I believe that was what he stipulated to, and which was covered at in the fair hearing report transcript, or excuse me, the fair hearing report at paragraph 64 through 68.
Doesn't, under 1.9C, is it your position that the rule is that a lawyer cannot report a crime against a client? I mean, a crime committed by a client? I struggle with understanding how that could possibly be the rule. even if it does violate a probation agreement that that lawyer himself had negotiated.
In this instance, and I think it's clear from the record, and these intentional actions were taken motivated by the desire for money. And on those facts, I believe it's improper what it was done.
Well, it isn't, I'm trying to, maybe I'm reading between the lines, I'm not certain, you can correct me, but it seems as though the real problem isn't the reporting of a crime. It's that this is, I mean, from your perspective, there wasn't actually a crime. It's almost a false report, or it's an abuse of legal process. It's a leveraging of the criminal report to obtain a financial benefit. But let's just say that the client had committed a battery against a lawyer. I mean, that law, there's nothing at all wrong with reporting a crime if it's done, if it's committed, right?
I can't argue that point, but I would say that SR's perception in this case was fear that his probation would be revoked and that he could be incarcerated. That's in the record. And that intentional act by Mr. Malone, I would continue to suggest is violative of the one.
Were there sufficient were there any fact findings by the panel that a crime had not been committed, or that this wasn't a good faith reporting of a crime?
If you'll give me just a moment. I believe what I have today present before you is what I've already mentioned, that there was a finding that Mr. Malone knew that his report could disadvantage us, including but not limited to the possible revocation of his probation.
And what I'm specifically asking is, how does that get you to a rule violation? Just because an attorney knows that a report of a criminal act could disadvantage alleged perpetrator of the crime. And of course it would disadvantage him. That's what I'm struggling with.
I believe one would also need to consider the attorney's duties under 1.6, which are implicated here, that he stepped out from his role of maintaining the information that he gained in the course of the representation to make this report, which relied on that information. And I believe that was a finding of the hearing panel.
Can I ask on 1.9, were the conditions of probation a matter of public record or generally known at the time of the criminal report?
I don't know about generally, certainly known to Mr. Malone and SR. I don't know about to what extent others that may have had some involvement in this had knowledge of it.
But I mean, that's relevant to the rule violation, right? Because once the information is generally known and not just a matter privy to the representation, 1.9 doesn't apply. Or am I misreading the rule?
I'm not sure I followed you. I'm sorry.
Okay, well, 1.9 says that, you can't use information relating to the representation to disadvantage a former client, except when that information has become generally known.
And I have no knowledge or awareness from my work in this case that the information was generally known. The other violations, 1.15A, that occurred because Mr. Malone did not hold the motorcycle title in his possession in connection with a representation separate from his own property. Instead, he applied to have the title transferred and then obtained insurance in his name, and then reported it stolen and filed suit. 3.3 violation occurred when Mr. Malone had already provided a $2,000 value on the motorcycle title transfer form, then stated a $6,000 value of the motorcycle in the petition he filed against SR. and did not inform the court that SR only owed him $3,700 at that time, instead implying that $6,000 was discipline. I see that I'm out of time, and so I'll just very quickly go through discipline. We recommend 90 days. The panel came back with 30 days. Mr. Malone suggests public censure. We stress that we believe 90 days is the appropriate level of discipline. The analysis of the panel was that his actions were a manifestation of Mr. Malone's selfishness, grounded in his misguided desire to teach SR a lesson in responsibility. I believe that makes sense, but in addition, I would cite to the selfish desire for money, which I think there's ample evidence of that. Mr. Malone, an experienced practitioner, said at the hearing that he exhibited terrible form in this matter, and I believe that these are the facts that would lead to that conclusion. The 90 days is, I think, supported if one looks at In re Harding, also a case that involves knowing violation of duty to a client causing actual injury. In this case, there was the potential injury to Mr. Rumford, actual injury in terms of the stress that he experienced according to his testimony. I'm mindful of the time that I have. I'm going to leave the other arguments for another day unless there are further questions. Thank you.
Grattan. Chair Ambrosio?
Madam Chief Justice, Your Honors, may it please the court. And I love big questions, so feel free to ask them. I think those are important questions. I love it. Let me start from the beginning. I agree with the panel found as far as the facts and as far as the rules violation. There's no doubt about that. My client will accept whatever you mete out. He's okay with the 90 days. He's okay with the 30 days suggested by the panel. He'd love a public censure, but he accepts the punishment for what was bad conduct, and he's mortified and humiliated by that conduct in this case. What he did.
Can you put in your own words what precisely is the bad conduct?
If you,
I don't deny that this fact scenario looks bad, but I'm just trying to drill down to what precisely it was.
you're going to get a contract with your client, okay? I took plenty of mortgages when I did criminal law on houses. I was going to represent you, and you had 100,000 mortgage, 100,000 equity in your house, and you only could come up with 10 front. I'd get a mortgage for the 90 behind. That's okay, as long as I send you to a lawyer, and that lawyer explains to you, so you're at arm's length, what you're giving up and what is laying in wait for you. If you come into me and give me 3 Rolexes and 2 diamond rings to represent you, as long as it's in a written agreement so everybody understands it and it's at arm's length, there's absolutely nothing wrong with that. And then if you don't—
Talking about, and again, this is the big picture question. You're talking about loaning, a lawyer loaning a client, you're advancing your fee, and you're taking collateral against future payments on that fee.
And I disagree with that terminology, Your Honor. I'm not advancing anything. I'm making sure you pay me for what I've done. I'm not advancing you anything. I'm protecting my posterior and protecting my pocketbook. I'm not advancing you. I'm taking what you have and filing it of record over in the court, in the clerk's office, or wherever you register a deeds office, that
It's
mortgage.
security against the debt.
Correct. That's
You
security.
would agree it's a debt.
Absolutely, it's a debt.
But it's a future debt in some ways, because all of the legal services have not yet been performed. So
That's true.
That seems to me to be some distinction in that way as well.
And I can accept that. I can accept that. The way you have to
And
do
to the chief's question, wouldn't it make a big difference whether this is a flat fee, upfront payment, or whether it's a hourly agreement, which is subject then to safekeeping of your client's property, has to be kept separately in a trust account? Because
agree
it's
with
not
that.
really your money until you earn it.
I agree with that. If you give me $100,000 to represent you in a murder case, all of it goes in the trust account.
Well, no.
Even if it's a flat fee, it goes in the trust account. That's our rules. And then I draw down against it as it's earned, because technically, in a flat fee, if you don't put in your contract that I draw so much down at the preliminary hearing, if I draw so much down during motion hearing, if I draw so much down during preparation for trial. It's not mine until the case is over. If you give me, that's the rule. Trust me, I did it and I studied this because this is how I earn my living,
I
as you
trust
know,
I
for all
trust you.
these years. And I wanted to make sure I get paid. Where my client made a mistake is he didn't lay it out, and that's what he's mortified his
Yeah,
conduct.
so it's the failure to document the agreements that's the problem.
I think that's one of the problems in this case. There's no doubt. And to answer Judge Rosen's question and also some of the others, my client is mortified that he actually called the police on his own client. Sure, if my client cold cocks me in the office when I'm representing him, okay, nothing wrong with me calling the police and accusing this person of battery. I think it's a little different, and this is where Terry made a mistake. When you owe me money and I have this security, to use your words, it's not okay to call the police and say he's stolen. I don't think that's okay. He said that, the panel said that, Mr. Stratton says that, we all agree with that. And by the way, it's public record because when you're put on probation, a judge tells the client on the record every probation mandate.
But the motorcycle was titled in Mr. Malone's name, correct?
Correct, as I remember, yes.
But isn't the problem that he had the title, but he really was holding it as security? And so there's some argument that the client still really owned the motorcycle.
Without question. Madam Justice, without question.
So that makes the theft report a lie, doesn't it?
Makes the theft a sharp practice, if not a lie.
Well,
A sharp practice. I
that's
use the
why I
word.
was trying to drill into that. Like either a crime was committed, in which case there's nothing at all wrong with reporting it, or it was a knowingly false report.
Shouldn't have done this. End of story. He shouldn't have done it. And
Or
we're
maybe
counting
the-
angels on the head of a pins again today. He should not have done it.
Or maybe it's just something in the middle and it's muddy. So therefore,
I'd rather go with what you're
Ethical
suggesting than
violation.
what the Lord of Justice on the other side is. It's a real problem. It's a real problem. Hence why Mr. Malone is mortified for what he did in this. He feels so embarrassed about this. He feels awful that they didn't get a contract, that he called the police. He feels bad about it. He was angry. I was always angry, still am when I don't get paid. I never get over it. But you have to do it a certain way. God love him, he did it an incorrect way. And let me talk a little more about what punishment should be meted out, because Mr. Malone accepts everything. When he shook hands with Mr. Stratton before, he said, no hard feelings at all. He doesn't have any hard feelings. He understands how this system works. He's embarrassed to be here. To take his license even for 30 days hurts worse than it should. What he did was wrong. He should be publicly censured. Again, he accepts it. I'm not sure he's really happy that I'm asking for a public censure because he wants to be castigated. He wants to punish. He thinks he should punish something. But a public censure hurts him. He really cares about how his peers look at him. He really cares about how this court looks at him. He really cares how the lawyers in this community and the citizens look at him. It bothers him that he's up here. He's bothered that it's going to be in those yellow books, as I call, more than anybody else who comes up here. Some of us, and it's a sin of mine, don't really care what people think. He does. He really does. And I think that he's a good man. He comes from a good family. He has run a good practice for years and years and years. He represents people in that community who need representation, especially the Latino community. Again, he feels so bad about this. And I think he would like to address you on those issues. By the way, before we go on, did I answer the big questions, the big picture questions? I love that part of this. Don't worry, I stand here.
This is my time.
Yes.
Okay. May it please the court, I do apologize to my client, my colleagues, the court, my family, and for my unethical conduct displayed in this case. My conduct has affected many. It has left another negative impression that such conduct is the rule rather than a rare exception. For that, I will always be ashamed and distressed. I am proud of our profession's insistence that the rules of professional responsibility be followed at all times. 47 years of experience working with members of the bar, I can firmly state that violations are indeed the rare exception rather than the rule. I do acknowledge need to repair the damage from my conduct. Making mistakes is not good, but can result in good things happening if that person is willing to not only repair the damage, but also to strive to be a better person. I do pledge to turn this regretful experience into a positive step to become a better person and a better lawyer, so that I may continue to use my license, continue to help those in need of ethical legal services. I wish to thank the Disciplinary Administrator's Office, my attorney, John Ambrosio, and this court for your dedicated service to our profession and to the public.
Questions, Mr. Malone?
Thank you.
Probably not. Okay. Mr. Stratton, you reserve 3 minutes.
Mention was made of Mr. Malone's service to the community. That was also a factor that the hearing panel considered in determining 30 days suspension rather than a greater period, I believe. And we are respectful of his contributions when he takes a case for someone who perhaps would otherwise not have counsel in a matter. We believe that when discipline is needed, it is needed regardless of the other actions of an attorney that could mitigate. Here, there's been an intentional act. We think that a 30-day suspension would be insufficient because when one looks at the support of the other lawyers that Mr. Malone rounded up and provided, it's clear that he has persons who could step in and cover a 30-day suspension, perhaps without a lot of difficulty. And there needs to be ample recognition of the actions of Mr. Malone, which we believe a 90-day would recognize more than the 30. It's difficult to say this in light of what Mr. Malone just said. I respect what he just said. However, he did stray significantly in this matter. Thank you.
All of you for your arguments today. The court will take this matter under advisement. We are now in recess until the 10:30 docket.